welcome to episode 13 of Counting on Law. On the second day of the 9-judge bench hearing for the Sabarimala matter, the Solicitor General of India, Tushar Mehta, argued in court that it is time for the concept of PILs to be done away with altogether. Unlike the 80s and 90s when the concept first took shape, he said, there is better access to courts today. The Chief Justice preferred to differ with this opinion. He said, drawing on his experience from Court Room No.1, that the court is extremely cautious in picking up PIL matters. What was absent in this to and fro, however, was data. Public interest litigations, or PILs, are different from ordinary petitions before the court for one core reason. It is a diluted locus standi. Now, what does that mean? It means that you can raise the matter of an election fraud or a famine in a village in front of the court without having gone through the voting process yourself or having gone through the hunger during the famine yourself. You can raise a matter that is of concern to you but does not directly affect you in the court through a public interest litigation. Now, the pro-abolishment camp or the anti-PIL camp will argue that PILs are fertile grounds for judicial activism through which judges eat into the powers of the legislature and the executive. On the other hand, people who prefer to let PILs stay will argue that if bleeding heart petitions are not taken up by the court on the flimsy procedural ground of locus standi, then that is massive injustice. Your opinion on this matter will depend on your ideological and political leanings. However, there is a lot that data can tell us. We illustrate this with 3 quick and sharp questions. Do PILs significantly overburden our courts? Who brings up PILs to courts, and why do they bring it up to courts at all? What are their success percentages like? These are crucial questions that both the Centre and the Supreme Court must investigate to have an empirically informed view on public interest litigations. To demonstrate this with an example, we draw upon the public interest litigation data of the Bombay High Court using the Professeer's database. First, how many PILs are filed in courts and what burden do they impose on the court's docket? Now, data across the past 5 years, as you will see in the graph displayed on screen, will show you that in no year in the past 5 years has PILs ever exceeded 0.5% of the court's overall docket size. Whatever PILs do at the Bombay High Court, overburdening the courts is not one of them. Second, who files PILs and what do they want? Now, the common perception is that PILs are filed by elite NGOs that have a particular agenda against the government or the judiciary. But in contrast, we find that 77% of the matters are filed by individuals before the court. Only 17% of the matters are filed by NGOs or local self-governments. And what do they file these for? Again, unlike the common perception, most people seem to file PILs for broken roads, potholes on the road, bad sanitation by the street, and a lot of other urban affairs related matters, with a list of other matters as would be visible in the chart in front of you, that they couldn't find remedy for in front of other arms of the government and had to seek the judiciary's intervention. Now, this is not to say that important matters and sensitive matters aren't brought to the court at all. If you look at the 3% matters, which are suo motu, taken by the court, or the court taking the matters on its own accord, we see a wide range of extremely sensitive matters. In one example, for instance, a retired judge writes a letter to the sitting judges of the Bombay High Court asking for its intervention into the issue of lack of education for children between the ages of 3 and 14 in Bombay. The court took this into account very swiftly. Likewise, there was another instance where the court observed from newspaper clippings that Mumbai's AQI has been depleting sharply. The court issued notices to the government as soon as it came across this fact. The court has also been curiously reserved in some other instances. In one instance, exercising its power under the PIL rules of 2010, the court asked the litigant to pay 2 lakh rupees as a security deposit before admitting the matter. In another instance, the court even went ahead to ask the petitioner to go and prove his bona fides by working for a week as a social worker. Within the limits of our data, it seems that the standard stereotype does not hold. These are not, as I said earlier, elite NGOs that are fighting the executive in a roundabout manner. These are average ordinary citizens filing petitions about broken roads in front of their homes, which has not been remedied by the municipal department. But at the same time, this is within the limits of our data. We only have access to petitioner names and scant order texts. The court, however, has access to detailed filing forms and documents, affidavits by the parties about their interest or the lack thereof in this matter, and their written pleadings. This wealth of information is not public data. but this can be accessed by the Supreme Court, the respective high courts, and even the central government to make deep, insightful analysis that can inform what sort of matters are admitted to the court and what admission standards should be put for these petitioners to begin with. And finally, what about their outcomes? Of the 1,408 matters that were disposed of by the court in the period of time that we studied, 29% were allowed. You can see the dismissal statistics and the withdrawal rates on the screen as well. Now, 29% is not a trivial number. This translates to the fact that in every 3 out of 10 instances where a person brings up a public interest litigation before the court, they get remedied through the court that they should have otherwise received through the executive or the legislative branch of the government. The interpretation of this statistic is very context driven too. Aparna Chandra and her co-authors in the book Court on Trial talk about how the declining win rates of petitioners in certain petitions before the Supreme Court is not indicative of an erosion of its pro-litigant stance. Alternatively and counterintuitively, it means that the court has been, they argue, over the years taking in matters at lower and lower thresholds, lending their ears to all kinds of matters and taking in cases with even a low win probability, thereby eventually lowering the win rates of the courts. Now, this is counterintuitive, and you need deep and intimate data-driven knowledge of each court, its rules of practice, its rules of how it deals with PILs, and its general inclinations and precedents to understand what these numbers mean. More such deep and intimate studies are required before making a decision on PILs. To close off, the economist and composer Edwards Deming is credited to have said, "In God we trust. All others must bring data. The government, our courts, and the rest of us all are certainly all others." For tweaking with a system as intimate to people's understanding of justice in India as PILs are, good quality data and its analysis is a minimum requirement. Thank you.